Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. What is wrong with Attorney General Andrew Bailey in Missouri? That's probably what a lot of people are thinking today, especially if they've been following the case of either Christopher Dunn or Sandra Him. Now, these are two people whose convictions were overturned after many years in custody. Christopher Dunn has been in for 33 years. Sandra Him had been in for 43 years. But then, after those decisions were made, the Missouri Attorney General worked feverishly to keep those two people in prison. Immediately after the order was issued in these cases, the state filed a notice of appeal, even though the order was not even final for purposes of appeal at that point. And so when you hear that these people were wrongly convicted, you quite naturally think, well, you got to let them out of jail, right? It may sound like Attorney General Andrew Bailey is off of his rocker when you look at the idea of keeping both of these folks in jail for an additional 6 to 10 months while the state appeals the decision of the circuit court. Maybe the AG thinks that, if you've been locked up for 30 or 40 years, what's another 8 months? But frankly, that kind of thinking is really awful. And when you get to really awful, Sandra Him's case was one that was especially awful. Now, Ms. Him, who had no connection to the victim that was murdered in that case, was a psychiatric patient at the inpatient hospital in St. Joseph, Missouri, and she was receiving treatment when she was targeted by the police as a potential murderer. Now, Ms. Him was repeatedly interviewed by the police under extremely coercive circumstances. Police conducted hours-long interviews with Ms. Him while she was in the hospital. At some point, she was so heavily medicated that she was unable to even hold her head up and had to be restrained and strapped into a chair. No police interview ought to be admissible in court when that is done. Ms. Him's lawyer presented no witnesses at her trial, which lasted just 1 day. The jury never heard about profoundly coercive circumstances under which the police conducted her interviews and got her statements, and those statements were the only evidence against her at trial. Now, if somebody is in a psychiatric hospital and they are medicated with psychotropic drugs, whatever statement you get from them cannot possibly be voluntary. And that was certainly the case. The jury also never heard about the crime scene evidence that supported Ms. Him's innocence. In fact, the crime scene evidence pointed to a St. Joseph police officer as the suspect in this lady's killing. That officer admitted to being near her home at the time of the murder, and his white pickup truck had been parked near the scene. He also attempted to use the murder victim's credit cards the day after her murder. The police hid this evidence that implicated their fellow police officer as a person who actually killed the victim. The victim's uniquely designed wishbone earrings, identified by the victim's father, who had given them to her, were found in the police officer's possession. In addition to that, witnesses could not corroborate the police officer's alibi. Now, a judge in Livingston County on June 14th cited evidence of actual innocence and overturned her conviction. The Midwest Innocence Project had worked very hard to free her, but appeals by the Attorney General, Andrew Bailey, from the Western District Court of Appeals, and then, on failing there, to the Missouri Supreme Court, kept that exonerated prisoner imprisoned at the Chillicothe Correctional Center. When the Missouri Supreme Court lifted that stay, during a court hearing the next day, Judge Ryan Horsman told the lawyers who were in court that if she wasn't released within hours, that the Attorney General himself would have to appear in court subject to a show cause order to show why he should not be held in contempt of court. She was released later that day, The Supreme Court had refused the Attorney General's request for a stay in that case, and in that case, the judge that freed him rebuked Bailey for having called the warden at the prison and telling him not to release him after a judicial order had been entered. It is generally considered to be an ethical violation to direct someone to disobey a court order. But that's what the AG did. And now the AG has done the same thing to Christopher Dunn, but at least now he has a little bit of cover for it. Christopher Dunn was convicted in 1990 for a murder, and the only two witnesses against him were a 12 and a 14-year-old boy who would later recant their identification and say the police had pressured them into doing that. Now, Dunn spent 33 years behind bars, and when Judge Singheiser overturned his conviction, he ordered that he be released immediately. And at that point, Mr. Bailey filed a writ at the Eastern District Court of Appeals and a request for a stay, and the Eastern District Court of Appeals refused to grant the stay. So he was minutes away from walking out of that prison when the AG filed a matter at the Supreme Court, and the Supreme Court issued the stay and would not allow him to leave the prison. And while a lot of people are saying that this is a politically driven matter, the arguments made in the writ filed at the court seem to suggest that the AG has more than just a leg to stand on. The statute that permitted the prosecutor to bring an action to overturn the conviction is a civil statute. In other words, you bring this action not in criminal court, but in civil court. And in an odd twist, like I said, even though he was convicted in the criminal court, he was freed by a civil court civil judgment. Civil cases obviously proceed under different rules than criminal cases, but in both cases, the state has 10 days after the judgment is final to file a notice of appeal. In Missouri, a circuit court retains jurisdiction over the civil case for 30 days and can alter or amend the judgment or vacate it at any time during those 30 days. That time frame is designed to allow for, among other things, a motion for a new trial. If a motion for a new trial is filed, the judgment doesn't become final until that motion is ruled on, or until 90 days passes, in which case the motion is denied. That's why, when a divorce decree is issued by Missouri courts, lawyers tell their clients not to tie the knot again until 30 days after the judgment, because the judge, if he vacated that judgment, could make them a bigamist if they did. So, because of this little bit of Missouri procedural law, Andrew Bailey filed a writ of prohibition or mandamus, and he filed these suggestions in support. Now, I'm going to apologize up front for the somewhat messy way this pleading looks. The Missouri Supreme Court has recently opened up access to CaseNet to people other than lawyers. And as you might guess, these are not official court records. They're just made public. They're a part of the filing, but they're not official until they are certified as a certified copy by the clerk of court. But unfortunately, the Missouri Supreme Court didn't think that just having this big watermark in the background that says not an official court record and was enough. So it added all these little lines in here, not an official court document, not an official court document, basically to make the point that this is not an official court document. So I apologize for the way this looks. If I could figure out a way to make this look better, I would, but I don't know how to do that. So these are the suggestions that were filed by the state of Missouri in support of a writ. And a writ of prohibition in this case is to prevent the usurpation of judicial power when a lower court lacks authority or jurisdiction, or to remedy an excess of authority, jurisdiction, or an abuse of discretion when the lower court lacks the power to act. And in this case, what they're saying is you could do it either as a writ of prohibition or as a writ of mandamus, because that's the appropriate remedy where no remedy exists through appeal. A writ should issue because the circuit court cannot yet order the enforcement of a not yet final judgment. So the way it works in civil court is you go to court and you get a judgment. Let's say you get a default judgment. And the default judgment says that you are entitled to an award of $10,000 from the defendant because the defendant didn't even show up and you were able to present the information and you got a $10,000 judgment. You can't enforce that judgment at that point. You can't go to his bank and ask to attach by garnishment any of his funds in the bank because the judgment isn't final. You have to wait 30 days. So after the 30 days is over, then and only then could you go and ask the court for a writ of garnishment against his bank account or something like that. And the reason for that is to give that person some time in the event he learns of the default to take some action on his own behalf and perhaps get the thing decided on the merits. But at any rate, the judge can't issue a writ of attachment or a writ of garnishment in that 30 days after it issues a judgment because the judgment isn't final. And that is essentially what this Attorney General is saying here. He points out that proceedings under Section 547.031 are civil in nature, and a civil judgment is not final until at least 30 days after its entry. And the court's order concludes with a command that the state of Missouri shall immediately discharge Christopher Dunn from its custody. But again, he doesn't have the authority to do that because the statutes don't permit it, because less than an hour after the order was entered, the state filed its notice of appeal, and when, as here, a notice of appeal is filed prematurely, such notice shall be considered as filed immediately after the time the judgment becomes final for purposes of appeal. So the notice of appeal will take effect 30 days after the judgment was entered. And so, as a result, the department cannot follow the circuit court's order because the judgment's not final. Well, that may or may not be the case. There are a lot of times before a case is final that orders are issued that must be obeyed. And the court could simply have withheld an entry of judgment and ordered his release, and there really wouldn't be too much that he could do about it other than come in and file a writ like this. But the problem in that situation would be that he doesn't have the ability to appeal an order that's not a final order of the court or a judgment. And they point out that in a factually similar case involving a Rule 2915 matter, which is a case that is filed, also a civil case, for post-conviction relief, the court ordered the immediate release, and the Western District Court of Appeals said, nope, not until that order is final. And indeed, they kept him in jail until after the order was final. And then down here, they quote the order, and they note how it ended because the court in that case, or the state in that case, did not file an appeal of the 2915 judgment. So it says, no provision of law allows the court below to order Dunn's release before the state's appeal is finally disposed. And they say, Missouri statutes and rules contemplate appellate bond during direct appeal, but there's no similar provision allowing for bond during a 547.031 appeal. Further, Missouri statutes require a criminal defendant to be taken into custody after the conclusion of a direct appeal and do not contemplate bond after that time. So, Section 547.031 does not include any provisions for bond, so the department can't release prisoners on bail or bond during these proceedings. So that's why the court, in essence, asked for a stay so that they could file their appeal. Now, this is the order of the Supreme Court. It was issued yesterday in this particular case, and here's what it says. It doesn't say much. Instead of checking one of these boxes as sustained, it says other. Order issued. Relator's motion for an emergency stay of the circuit court proceedings is sustained. Enforcement of the circuit court's order releasing Christopher Dunn is stayed. Respondent is ordered to file suggestions in opposition before 5 p.m. on July 26th, which would be 5 p.m. Friday, and any reply suggestions are due on or before 5 p.m. on July 29th, which would be 3 days later, probably by Monday. So they're going to make the Attorney General's office work over the weekend, is what they're going to do. and it is signed by the Chief Justice Mary Rhodes Russell. Now, because I did clerk at the court and because I spent the majority of my career in Jefferson City, Missouri, I know Judge Russell very well. And she issued this order essentially to hold the status quo so that they could deal appropriately with this particular writ. Because when the state filed it, the other party didn't get an opportunity to file anything in response. She's now telling Christopher Dunn's counsel, hey guys, you need to send us something and let us know what you think about this. And she's given the Attorney General a right to reply to that pleading, and then they'll make their determination. Of all of the judges on the Supreme Court, Mary Rhodes Russell is, I believe, one of the fairest, nicest, most compassionate people on the court. And I have to admit, I've had a very favorable ruling in a case that I was in from Judge Russell. So, I guess that would tend to make me think highly of her. But even if she'd never even written that opinion, I would still have a very high opinion of her because of the way she treats litigants in her court, because of the way she asks questions, and because just generally of her demeanor as a judge. She is everything a judge ought to be. So this was not an order that was issued in some kind of political nature. Now, it may very well be that the Attorney General is seeking relief because of a political, he wants to get political points or something, score something for being tough on crime. I don't know. I don't know the Attorney General at all. I've never met him, and I can't really speak to his character. But I can speak to the idea that in many respects, what the Attorney General is doing is specifically what the courts and what the law in Missouri would require him to do. It would require him to at least mount an opposition if he indeed disagreed with the holding of the circuit court. Now, I don't know whether he does or whether he doesn't, but my guess is he doesn't agree with it because he's filed an appeal. And you may think that this is indeed a political thing, but I don't really believe so. Now, the Midwest Innocence Project has not filed a response as of yet. They have until tomorrow at 5, so I suspect they'll take every bit of that so they can do thorough research and brief this and get it into the court. And of course, there's electronic filing in Missouri, so they don't actually have to go to Jefferson City to file this. They can put it on a computer and send it up there. After they do that, Bailey gets the reply, as I said, by Monday. Thereafter, the court can issue the writ, which will extend the proceedings for a lot longer, or it can deny the writ and vacate the stay. In this case, denial of the writ and vacation of the stay would seem to be the appropriate route to go. The evidence has never supported Dunn's conviction. And like Sandra Him, there are questions about the role of racism and police overpressure and how those played out in his identification as the killer, because the people who identified him were later recanting and saying, well, the cops sort of made us say that. Now, you might be thinking that, like I said, that Bailey needs to stop doing this, but I would caution against that. And the reason for that is because there is a third case in the works right now where these types of issues are being brought up, and I'm not so sure that that is a wrongful conviction. In fact, I'm pretty sure that it is a correct conviction. And so that case is the case of Marcellus Williams. Now, Williams had a direct appeal to the Supreme Court. He was convicted of murder, and he was sentenced to the death penalty. And as you know, I'm not a big fan of the death penalty, but the jury sentenced him to the death penalty. He had a direct appeal to the Supreme Court, and the following is from the Supreme Court's opinion. On August 11th, 1998, Williams drove his grandfather's Buick LeSabre to a bus stop and caught a bus to University City, Missouri. Once there, he began looking for a house to break into. Williams came across the home of Felicia Gale. He knocked on the front door, but no one answered. Williams then knocked out a window pane near the door, reached in, unlocked the door, and entered Gale's home. He went to the second floor and heard water running in the shower, and that was because Ms. Gale was in there. Williams went back downstairs, rummaged through the kitchen, found a large butcher knife, and waited. Gail left the shower and called out, asking if anyone was there, and then she came downstairs, and Williams attacked her. I won't go into exactly what happened there, but suffice it to say that the wounds inflicted by Williams were fatal. He went upstairs to the bathroom, I'm assuming the same bathroom that Ms. Gale had been in, and washed off. And he took his jacket and put it on to conceal the blood on his shirt. And before leaving, Williams took the woman's purse and her husband's laptop computer and the black carrying case, and he put it in his backpack and left. The purse contained, among other things, a St. Louis Post-Dispatch ruler and a calculator. Williams left out the front door and caught a bus back to the Buick. After returning to the car, Williams picked up his girlfriend, Laura Asaro, and Asaro noticed that despite the summer heat, Williams was wearing a jacket. When he removed the jacket, Asaro noticed that Williams' shirt was bloody and that he had scratches on his neck. Williams claimed that he'd been in a fight. Later in the day, Williams put his bloody clothes in the backpack and threw them in a sewer drain, claiming he no longer wanted them. Asaro also saw a laptop computer in the car. A day or two after the murder, Williams sold the laptop to Glenn Roberts. The next day, Asaro went to retrieve some clothes from the trunk of the car. Williams did not want her to look in the trunk and tried to push her away. Before he could, Asaro snatched a purse from the trunk. She looked inside and found Gale's Missouri State identification card and a black coin purse. Asaro demanded that Williams explain why he had Gale's purse. Williams then confessed that the purse belonged to a woman that he had killed. He explained in detail how he went into the kitchen and did what he did. And then basically he explained in great detail how he wound up killing her. After relaying the details of the murder, Williams grabbed Asaro by the throat and threatened to kill her, her children, and her mother if she ever told anyone. And then on August 31st, 1998, Williams was arrested on unrelated charges and put in the St. Louis City Workhouse, which is what they call the jail there. From April until June of 1999, Williams shared a cell with Henry Cole. One evening in May, Cole and Williams were watching television and saw a news report about Gale's murder. And shortly after that report, Williams told Cole that he had committed the crime. Over the next few weeks, Cole and Williams had several conversations about that. As he had done with Laura Asaro, Williams went into considerable detail about how he had broken into the house and killed the woman. Based on this evidence, the jury convicted Williams and the court sentenced him to death. His direct appeal to the Missouri Supreme Court was affirmed. And that same court has set a date for him to meet his maker in September of this year. Williams' motion to vacate the conviction centers, I believe, on DNA evidence and how they could get around the fact that he knew facts about this that nobody else knew and that he had bragged about it to at least two people. I'm not sure how they get past that with an actual innocence requirement. In other words, in order to get released, you have to show actual innocence. You don't just have to show that there were things that could have been done better. So perhaps it's a good thing for the state to have Bailey bring these attacks on post-conviction vacations of judgment, because courts do make errors and they sometimes admit evidence that's not admissible. But if I were advising Bailey, I would suggest that rather than attacking every case, that you only attack the clear cases like Marcellus Williams, and you leave cases like him and Dunn, where there were really pretty egregious miscarriages of justice, leave them off the table. It would be better to attack only the more outrageous ones like Williams. That's what I think. I'd love to know what you think. Please like and share this video, and in addition, please leave your comments down in the comments down below, or if you want to, you can email me your comments at the address above. I'd be interested in hearing from you what you think about this, not only about just opposing things where there's a clear miscarriage of justice, but also about this process in general. Should there be an 11th hour after 33-year method to erase these questionable convictions, particularly where witnesses may have died and other things may have happened that have made it more difficult to proceed? I would really appreciate knowing what you guys think about that. Well, just like the Midwest Innocence Project here did a great kindness for Sandra Him and Christopher Dunn, It would be a marvelous thing if you would do a kindness for someone. You can always, of course, donate to some of these innocence projects. You can find that information online. But even if all you do today is open a door for somebody, you will have made the world a better place. After you do that, come on back down here tomorrow, join me at the beach, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.